we are on record this morning as it relates to a pretrial on petition 1 and petition 2 for both parents. Petition 1 appears to concern just mom. May I have the names of our participants, please?
Good morning, Nicole Underwood, lawyer guardian ad litem for the minor children.
Good morning, Troy Tipton, appearing on behalf of the department. We got Megan McVeigh, excuse me, ongoing CPS investigator to my mind.
Megan McVeigh from the department.
All right, and we have Ms. Conrad, are you handling the foster care services on this?
Good morning. Yes, I'm the assigned foster care worker for the case currently.
Okay, thank you. Go ahead.
Good morning. May I please the court, Randy Thompson with and on behalf of the respondent mother, Robin Hardy, who is also present and seated to my right today.
Name for the record, please.
Robin Hardy. They're gonna do monitoring for father Tyler Long.
Tyler Long.
Thank you. All right, any preliminary matters as we prepare for trial on 2/21 of 25?
Your Honor, I do have two doctors that are subpoenaed for the case, and I'm asking for the parties' consent for them to testify via Zoom, and if that's the case, then I would prepare a stipend order. If not, then I'll just file a motion. You're the case, hear it before our trial date on February 21st.
Okay, Ms. Thompson, your position?
The only concern I have, Your Honor, is that I am waiting on some medical records still to send to an expert. I'm a little concerned about timing to be able to get those scans in, to send them to my expert, to have my expert review them, and then be ready for trial on the 21st. I understand that Mr. Tipton has requested those. I don't know if we have a date certain that we're gonna have those. So that therein is my concern about being ready to go on the 21st.
Well, I was told that the records were mailed to my client from the hospital, and I assured all parties that once I received them, I will personally pick them up from my client and get them to the attorneys as soon as I can. I'm sorry, I don't have a date certain that they would be that the department would receive them via mail. So I think that there will be enough time, Your Honor, for the all experts to review those skeletal surveys. The other medical records I've provided already.
Very good. All right, there was a bit of confusion too, Ms. Thompson. So in your pleadings, you requested a jury trial, but then you also indicated a bench trial. So what is the preference of your client as it relates to jury or bench?
I believe that I just requested a judge demand, but maybe something got mixed up.
Well, there was a judge demand and a jury demand on page 3, beginning with your appearance.
Yeah, we just, some courts have referees preside, and so that we were just requesting for a judge to hear over that and a jury demand. So yes, we have requested a jury demand. My client is willing to proceed forward with that.
So you want a jury trial?
Yes.
Okay, that's what I wanted to clarify, because it doesn't look like we'll have enough time on the 21st if a jury trial is what's requested. I usually plan those for 2 days so that we can get all the proofs in and then invite the jury back for deliberation the next day as necessary. And especially if we're going to have a couple of different experts, I don't think 1 day would be enough time. So that was the other reason. And then there's 2 petitions as it relates to your client, petitions 1 and 2. So are we just proceeding on petition 2, Mr. Tipton, or do you want to bifurcate the proceedings as it relates to those?
We would just proceed on petition 2.
Okay. Ms. Thompson, is that any comment on that or argument?
I just want to make sure I have the correct petition petition 2 that I am looking at. Is that the one dated September 24th, 2024?
Well, maybe Mr. Tipton, you can clarify this for us, because it looks like maybe there was some confusion on the petition numbers.
Only 12/13.
There's one dated, received December 13th, and then September 24th, 2024. So
December 13th.
December 13th.
Yeah,
Okay.
sure.
So it is, I think that's your first amended petition, and it's reflected as petition 2, but perhaps.
First, okay, I see, petition number 2.
I'm not sure that that's actually petition 2, Mr. Tipton. I don't know. Might just be a first amended, but I'll leave you to that, as long as we all know which one we're proceeding on,
Okay.
that's okay with me. So the one filed December 13th, 2024 will be scheduled for jury trial then. All right, so your options are to keep the 21st, and then your jury will have to come back on the Monday after that, or if you want to look at different dates, or if you're considering an adjournment based on your concerns about the expert testimony and the availability for review of those records, you're not looking at time until April 7th and 8th this year. And that would, you would be a backup to a delinquency jury trial. Would be the first available 2-day spot. And I can try to move a few things around here and there as well, but that would be the first available.
And Judge, I'm on that delinquency trial and I've been talking with prosecutors, so I think that should be off.
Okay.
So April 7th and 8th?
Yes.
Okay.
That would be for both parents.
That actually works better for me, as I have a bench trial also scheduled for February 21st in Clinton County, but I'm completely open April 7th and 8th.
I have no problem with adjourning, having a jury trial on April 7th and 8th, and I think that we resolve the issue with the medical records and the skeletal survey and the experts having time to review them.
And I don't think I put on the record that I don't have a problem with Mr. Tipton's experts appearing via Zoom, as I will likely have the same issue. I would just ask that they have the records, just because I've had that issue before, they don't have the records with them. And we've got the records here. I know we can possibly screen share, but just as long as they have the records that they can reference during that testimony, I don't have a problem with that.
Sweet.
So I'm prepared to step in order, Your Honor.
Very good. I appreciate that. All right, should the order reflect then that the parties have agreed, or simply that Ms. Thompson, you're moving for the adjournment officially? Because obviously your clients are the ones who have the right to have the case read within a certain period of time.
I would request that, I mean, I don't know if it's by agreement, but if not, I would request that so that we can obtain appropriate experts and have time for
Yes.
my experts to review everything.
Ms. Dumont, does your client also wish to have an adjournment?
Yes, Your Honor, we have no objection. I think it's in everybody's best interest to get the opinion back from the expert with all of the medical records.
Very well. All right, if that does sound like good cause for adjournment, so we will adjourn from February 21st to April 7th and 8th to allow for jury. Do you want me to schedule it for, I have 2.5 days. I have the morning of the 9th as well, if you think you're gonna have that many witnesses.
I think to be safe, my last one I got going on right now, we thought was gonna take a week, and we're on week 2 and still not finished. So 2.5 days would probably, if the court has the time, I guess I would say yes, set it aside, especially with the jury trial.
Okay, we'll go ahead and schedule that for those 3 days then. Do you think you're gonna be done in 3 days?
Oh, I hope so.
Me too. If you're not, then I need to know, because the calendar is kind of crazy after that, as far as very busy for my docket.
I guess I don't even know what to say. I think that, I mean, some of it largely depends on how many witnesses Mr. Tipton plans to call. I certainly would have at least an expert, ideally, if we're moving forward, so.
I have enough time to clear the rest of that week, if that's what you think would be appropriate or necessary.
Honestly, with a jury trial, I do think that would not be a bad idea.
Counselors?
We have no objection.
No objection.
I have no position on the amount of time.
All right. What are your thoughts about the adjournment, Ms. Underwood?
I think that adjournment is in the best interest of the children, considering the parties are seeking additional information and records. And this party is seeing the children pretty regularly. So I just think that the department, we need to consider, we don't see any time it's going to look like over the next couple of months. I do believe it's appropriate.
Thank you. Appreciate that. Do we need to have a pretrial review?
That'd be helpful.
Well, the department, for funding purposes, I know, and for services, to monitor adequate parenting time and services and supports to the parent and the children, especially with an adjournment out until April, it seems like it might be appropriate. It doesn't look like there's been a report prepared for today necessarily, so I could schedule that out. What are your thoughts, Mr. Tipton?
Yes, Your Honor, I think that's appropriate. Thank you.
All right, so I'm gonna schedule the whole week of April 7th then for this trial, and I'll notify my assistant. He can start moving a couple things that are already scheduled during that week, so that you'll have that whole week. And for a pretrial review, how much time do you think you're gonna need for that?
Yeah.
Yeah, I would defer to the foster care specialist on how much time she would need to prepare that report.
I can consolidate it with a final pretrial, March 19th. A month ahead of the trial, which hopefully would give you some time to get those records exchanged and have a better idea of what your time would look like.
Your Honor, I will not be here on the 19th
Okay, thank you for that heads up.
through the next week.
What are the dates exactly you'll be out, if you don't mind?
The 19th through the 28th.
Thank you. All right, so then looking ahead of that, can carve some time out. The week before that, Wednesday, March 12th.
I'm available.
At 1:30?
I have a jury trial, Your Honor.
Okay,
I'm sorry, March 12th.
Monday, March 10th at 9?
So that's when my jury trial starts. So it's expected to go those all 3 days.
What about Thursday, March 20th at like 11?
That's when I'll be out.
Yes.
Oh, you're out that day, sorry. Okay. Monday, March 30th, while you're out, you said through the 31st?
I should be back. I'll be back that day.
I have Monday, March 31st at 1:30. It's not ideal because it's only a week before your trial, but
It's
is that
fine
on
with me.
everyone's schedules?
Yes.
That works.
Okay, I only have an hour that day, so
I'm sorry, what did you say?
Monday,
1:30?
March 31st at 1:30.
Yes.
All right, so we'll do our final pretrial and a review on Monday, March 31st at 1:30 p.m. Jury trial forms, verdict forms, jury instructions, and what are your questions? Please have those prepared. I would ask you, in fact, to maybe even have those filed the week before that, by the 24th, so that if there's any issues with those, that can be resolved at the pretrial, so that we can be ready for the jury trial the following week. Unless you need more time than that. Yes. The pretrial order will reflect also that jury instructions, voir dire questions, and voir dire verdict forms will be due March 24th, no later than March 24th, to be, and then any motions that need to be filed or objections that need to be filed would need to be, well, maybe we should back it up to the 17th, so you have a week. Because if you need to file an objection to be heard on the 31st, that would need to be filed, obviously, within the next few days. So do you want the 17th, or do you want me to back it up even further to like the 10th? So you have a week or two to look at those and exchange those.
I don't have a preference.
I'm fine with the 10th.
Okay, so let's make that.
Makes
due
sense,
date
gives
March
everybody
10th.
extra time.
Okay, so March 10th then for jury instructions, voir dire questions and verdict forms with
Right.
objections to be filed and set to be heard with the pretrial on the 31st. Final witness and exhibit lists to be filed and exchanged by the 10th as well, please. And if you're going to have records that both sides are using, I know it's a lot easier for the jury and for the bench to have a consolidated binder with those. So I would ask the parties to work together to create something so that we're not trying to figure out, you know, plaintiff's A corresponds to respondents 4. It's a lot easier and a lot better for the jury if that's organized ahead of time. So I'll ask you all to work together on that. And if you don't have that finished by the 31st, you can count on me telling you that that's gonna be something you'll have to have, you know, by the end of that particular week, but we can sort through that too if that's gonna be an issue. If there's any objections over exhibits. All right, any other issues that should be addressed for purposes of today's pretrial?
Your Honor, if I could just briefly address parenting time.
Sure.
Currently, right now, Miss Hardy sees the children. She has 3 times a week at 4 hours. One of those is supervised by the department, and then the remaining is supervised by the placement, which is Miss Hardy's father. We would request at this time, this is not a termination petition. The visitations are going well. I haven't seen anything that would indicate that otherwise. So we would request, considering this is, you know, regardless of how we move forward, regardless of whether or not the court takes jurisdiction, that, you know, reunification is the plan. So we would request at least one additional day, 4 hours parenting time.
And Your Honor, we would request the same for Dad as well. They're already executing the same parenting time schedule as.
Has that, have you addressed that with the caseworker before today by any chance?
I have not, Your Honor.
Okay, because I think practically
Yes.
speaking, that would probably need to be worked out during a family team meeting. Obviously, Ms. Underwood is gonna wanna look at the burden on the children for that regard to transportation and some of the other factors that are similarly considered in parenting time cases and civil cases, frankly. And to make sure that that's gonna be in the best interest of the children. Ms. Underwood, do you have an opinion on that right off, or would you need more time?
I think in general, Your Honor, I was able to meet with RL yesterday, the younger child. I know he is still nursing. And so to maintain that, I'm not necessarily opposed to one additional day if the parties are willing to accommodate that, which is family placement. So I think that they would. I know that the older child, AL, is struggling. So it's one of those where would more frequent contact be more difficult because it's more days per week that she's going to have to go back to her grandparents' house and not have her parents there, or would one additional day, you know, be more time for the children to continue bonding with their parents? I think a family team meeting is appropriate, but again, I'm not opposed to considering an expansion, considering we have a few months before the next hearing.
Ms. Conrad, your thoughts?
I will certainly set up a family team meeting for anyone interested in discussing this specific thing further. We can do that quickly via Zoom in the next few days. And my only thought at this time would be, yes, having everyone weigh in on whether the increase in frequency and duration would be confusing to AL or if it would be helpful to AL, and we can talk about that as a group for sure. Secondly, I would like to just bring up that there has not been, I would like there to be absolute consistent compliance with the drug screens to monitor the THC levels if we're going to be increasing breastfeeding opportunities. So there really needs to be, you know, at least weekly drug screens done by mom to show that the THC is no longer a concern.
Yes, that's pretty standard in my courtroom, Ms. Thompson. There's no breastfeeding if there's THC or any other substances in the mother's body. So she wants to provide that, which is obviously a benefit to the child and for her and for the bond between the mother and the child. She'll have to maintain her sobriety. All right, that would be how I would be inclined to address that parenting time increase. Request for that would be asking for all the parties to come together to do that family team meeting with Ms. Conrad. I would endorse her concerns and safety planning around the THC usage as well as anything else that may compromise the time between the mother and the child. Ms. Conrad or Ms. McVeigh, whoever can answer this, has there been trauma screens completed on the children? Are there trauma assessments pending or referrals for the children or the older child at least?
Yes, so there's a new system in place, and a Michigan's assessment was done by a specialist in regards to AL, especially because of her age, and a referral has been requested through our local CMH to have an assessment done to see if she could benefit from trauma services. So I will be starting that referral process.
All right, as a part of that, would they be able to consider the child and the parenting time and how that's affecting the child and whether or not an increase could be beneficial or detrimental?
We could request that for sure.
I think that
A
would be
weigh in
useful.
from them.
I would appreciate that.
Okay.
Okay, any other thoughts on parenting time or my directives to Ms. Conrad, frankly?
I don't have anything further, Your Honor.
I believe in prior hearings, there were issues with who was conducting drug screening and how that was done, so I would just like a little bit of clarification on whether Ms. Conrad will be administering those or if there will be another way in order to have that facilitated.
Your Honor, if I can answer that, I know that since December, Ms. Hardy has been testing with her doctor weekly, like consistently since December.
Ms. Conrad, are you able to review those? Do you have concerns about that? What's your approach on that issue?
Yes, so there were 2 screens in December. They were not weekly. And then I did get a text from Ms. Hardy that she went this past week in January, but not weekly in January. So I have not gotten the results on 12/24 were negative for THC. So that was good to see. And then I have requested the results of the drug screen from this week and have not yet received them. We need to have weekly at a minimum to ensure that the THC levels are staying negative and not increasing for a while. We can monitor for a while and then we can reduce or get rid of, but this is new. This sobriety is very new.
Also, have you been able to talk with the doctor's office about their procedures and how they conduct those tests to ensure that there's no chance that we're getting false positives or that the levels are appropriate to make sure that there's no active usage or residual usage, all of those issues that come along with testing?
Right. I have not talked to the IHA professionals. I know CPS as part of their work with Ms. Hardy had arranged for those and had approved those as her screen of choice. And they are able to give pretty specific numbers because it was demonstrating a continual decrease in the amount in her system. So I have not had a specific conversation. I can if there are specific questions you would like me to ask, or we can require forensic fluid screens. That would be the other option because we're familiar with those.
Ms. Underwood?
Your Honor, as long as the ongoing worker is comfortable with the results from the doctor, I would defer to the court or to Ms. Conrad on whether requiring forensic fluids would be more appropriate in this case, but it sounds like Ms. Hardy would be willing to continue with weekly screens.
Very good. I think, I would leave it also to Ms. Conrad and Ms. McVeigh and Ms. Underwood to raise any concerns on those points and to also discuss that during the family team meeting on period of time. Anything else?
I don't have anything.
Nothing further, Your Honor. Thank you.
Nothing further, thank you.
Okay, all right. Well, all prior orders will remain in full force and effect then, and we'll see you all in March, the end of March, for our final pretrial. I wish you the best of luck moving through our discovery issues. And hopefully, if anything comes up between now and then, you know where to find me, whether it's by motion or even just asking for a settlement conference if any issues come up. If you're looking at retaining an expert, obviously I would maybe anticipate a motion to have that person vetted for those purposes, or a stipulation if the rest of your co-counsel is satisfied with that person's requirements, but I don't want to have to deal with deciding whether or not a person is an expert on the day of trial.
Certainly, Your Honor.
So I appreciate you being cognizant of that issue.